Makes more statements.
And I did record the call.
That are false to this.
I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because he's interfered.
Doing the training about the people.
And Mary Rubio, on behalf of Mr. Lee, I am standing in for the attorney of record, David Burgess, with Mr. Lee's consent, to my knowledge. Is that correct, sir? That is okay for me to stand in for you right now?
Yes.
Okay. Could you please state your name?
Literally.
What is that noise?
Shouldn't you check? I don't feel safe. Why are you just pointing? What? It'll stop at some point.
I feel very safe.
Wow, I know. He's like, you are all over it. Yes.
Buckle up, guys. Today we're going straight into a courtroom moment that erupts faster than anyone expected. Before the hearing even settles, the defendant tries to control the narrative, hinting at recorded calls and pushing his own version of events. But the judge quickly recognizes the pattern, cuts him off, and shuts it down. One wrong move, and the courtroom tension spikes instantly.
All right, go ahead. What are we doing?
Well, Your Honor, a few things. First of all, I've been in communication with Mr. Burgess and Mr. Arabo, who is representing the victim of the case, Mr. Quasny. Apparently, Mr. Lee called Mr. Arabo and offered to, in exchange, there's a pending case where Mr. Quasny is the defendant of an AMV against Mr. Lee. Mr. Lee contacted Mr. Arabo and offered to essentially not testify in that case if Mr. Quasny agreed not to testify in this case. There are statements that are essentially saying, in exchange for Mr. Quasny, victim in this case, not testifying, I will also not testify. That is highly concerning, of course. I was given this information yesterday. I asked Mr. Arabo to forward that call to myself, Mr. Burgess, and the officer in charge because we wanted documented for potential additional charges. But this all transpired yesterday. We got the recording as of this morning. With that said, of course, I think it's appropriate to have an adjournment. Mr. Burgess agrees with that.
But does that recording indicate that?
Yes, Your Honor, have either one.
Okay. I myself have not listened to the
Right after the outburst, the prosecution steps in with a revelation that shifts the entire tone of the hearing. They explain a disturbing phone call where Mr. Lee allegedly tried to influence testimony in another case. It becomes clear that this isn't just miscommunication. It's behavior that could threaten the integrity of two separate court proceedings, raising alarms for everyone present.
recording. I was just asked to stand in on behalf of Mr. Burgess. He's at a hearing in Lansing. However, I did speak to Mr. Lee about it today. Mr. Lee indicated some of the content of the conversation to me. He also indicated, just FYI, that he himself recorded it.
But just so that I have this right, the defendant, because of something else, is urging, enticing, or in some other way interfering with testimony of witnesses in this case.
I can't agree to that characterization because I haven't heard it. I don't know.
Well, you want to listen to, because that's what I'm being told.
But yes, I understand. I understand that is what's being presented. I also want to indicate that. Go ahead. I'm sorry. Mr. Lee has indicated to me some things. I have advised him to be careful of what he would want to say to Your Honor, but he seems to feel that.
As the allegations unfold, the judge steps in, trying to confirm exactly what happened. He presses for clarity, questioning whether this was a deliberate attempt to interfere with witnesses. The attorney tries to soften the characterization, but the judge isn't buying vague explanations. The room tightens as the court realizes the call could be far more serious than initially suggested.
He needed to make that phone call because he wants to moved to have Mr. Burgess removed and he wants to get a different attorney. Mr. Lee has indicated to me he also wants to address the court. I again did advise him I would not go into the content of that conversation as there could be potential pending new charges. With that said, Mr. Lee, what is it you wanted to say?
Yes, Judge, I indicated to, what's your name?
Ms. Rubio.
To Ms. Rubio that for a little bit over a month, I contacted my attorney, Mr. Burgess, and I instructed him to contact the lawyers from both sides, the prosecution and the other side that represented Mr. Quasny, and I instructed him to offer a plea or to negotiate some sort of settlement, and he indicated that he would do that. He indicated that he had done that. He indicated that he had reached out to Mr. Arabo and the prosecutor regarding making some sort of plea agreement. Him and I discussed what that could be.
Mr. Lee finally takes his turn, laying out a long, detailed story about his attempts to reach his attorney. He claims he asked for negotiations, insists his lawyer told him progress was being made, and paints himself as someone misled, not malicious. But even as he explains, every word he says edges him closer to admitting actions that may carry legal consequences he's not fully aware of.
And so now, fast forward, yesterday, I contacted Mr. Burgess and I said, hey, have you reached out or have you heard anything from Mr. Arabo and the prosecutor? He said, and he indicated that he had not heard anything and that he had reached out to both attorneys multiple times. I knew that to be a lie. I suspected that to be a lie. And I knew that if I were to have him or to ask you to have him removed or substituted, that I would have to prove under Strickland versus Washington that he...
I don't know. Are you a lawyer?
I was...
Mr. Lee, no. To my knowledge, no.
So I knew that I had to prove that he was ineffective. I knew that I had to prove that our breakdown was egregious. So I recorded the call myself. And I called Mr. Arabo and I asked if Mr. Burgess reached out and discussed any sort of plea negotiations. Mr. Arabo said, no, sir. He had not had any communications with my attorney. So I confirmed with Mr. Arabo that he had not received any communications about any kind of negotiations with any kind of plea agreements on my behalf.
I'm so sorry to interrupt Mr. Lee before he makes more statements.
And I did record the call. I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements. In the call that was sent to us, there is indication there's no discussion of a plea. Not what was sent to me. That was recorded by Mr. Arabo. There's very clear that there will be no testimony in his case if Mr. Quasny agrees not to testify in this case.
So I have the text messages.
Further false statements are made to the court, which is not necessarily a problem for me, but I want to make sure that Mr. Lee's rights are preserved.
I have the text messages.
I want to listen.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because if he's interfered with it, that's going to be a whole other issue.
I will try to reach him, but I know he is in Lansing, so I'm not certain.
Well, even if he appears, has Mr. Burgess heard the calls?
I don't know, Your Honor. They were sent this morning. I asked Mr. Arabo to send them right away yesterday, and we received them this morning. Mr. Arabo can also be available via Zoom if necessary.
All right. Okay. I'm just letting you know that what I'm hearing is extremely disturbing.
I completely understand that.
And so I'm gonna give an opportunity for the defense to give me some explanation.
The moment takes a sharper turn as Mr. Lee admits he personally recorded the phone call. He insists he only wanted proof that his attorney wasn't doing his job, but the prosecution pushes back, pointing toward a different motive. As the lawyer reveals text messages and conversations that contradict his story, the judge becomes visibly concerned, sensing something far deeper happening behind the scenes.
but I'm inclined at this point, I'm gonna hold him in custody. I'm inclined at this point to revoke his bond.
I understand.
Okay?
Okay.
All right.
Thank you, Your Honor.
Thank you. Somebody needs to listen to him.
Just listen to it.
Have you heard him? Or,
Just now. Oscar and I listened to it together.
okay. All right. I'll recall that momentarily.
And then everyone else gets folded.
Everybody else is holding. And
Mr. Kennedy. I'm dying. That's one I think it's
four.
Yeah.
Okay.
Yep.
So this one we're going last. Right, no.
No. This one.
Here the courtroom boils over. The judge, hearing Mr. Lee challenging the narrative yet again, snaps and orders him removed. It's clear he's heard enough interruptions, enough circular explanations, and enough contradictions. The judge demands the lead attorney be summoned, and the severity of the situation becomes unmistakable. What started as a routine hearing is now a potential witness tampering case.
That's fine. So just hold down. It's between these two. What happened to
That was at 2:00. We haven't gotten there yet.
Oh,
I haven't talked to you about those at all yet.
ow. Okay. All right, but this one has one. And then we gotta bring Lee back out. So who's on this one?
This is for witnesses with Miss Tanha and I believe Miss Ackerley.
Okay. So then this is good night.
9 is Burkett.
How many witnesses on that one witness? Okay. Get Mr. Burkett in here. We'll handle that one. I'm going to take a brief break. We'll handle that one. Then I'll get Mr. Lee out. Okay.
Thank you, Your Honor.
And deal with Lee.
That's my order then.
All right, court is standing for Larry Lee.
All right.
As Mr. Lee is escorted out, the judge discusses the next steps with counsel. With the new recording in hand, he makes it clear he may revoke bond entirely. The prosecution confirms when the audio was received and hints that more charges could follow. The judge's tone shifts from irritation to deep concern, signaling that what he heard was more than poor judgment. It may be criminal conduct.
Good afternoon, Your Honor. Marie Tanha, Assistant Prosecuting Attorney on behalf of the people.
I forgot to wait a second.
And Mary Rubio, again, on behalf of Mr. Lee, who is making his way to the podium.
There's additional counsel that is on Zoom.
I'm sorry?
Oh, there you
Good
go.
afternoon, Your Honor. May it please this honorable court, Joseph Arabo on behalf of Stephen Quasny.
All right. And I'm presuming everybody except the court has heard the phone call.
What I heard was the recording the prosecutor gave me, which appears to be a less than 2-minute portion of a phone call. I think she would agree it's not an entire phone call.
That's correct, Your Honor. It's what Mr. Rubble sent me, as well as Mr. Burgess, and law enforcement as of this morning.
All right. And that
The courtroom pivots into administrative mode. Witnesses are identified, cases are reordered, and the court briefly steps back to reset. Even in this quiet procedural moment, the underlying tension remains. Everyone knows Mr. Lee will return shortly, and with the recording at the center of the storm, the next phase of this hearing is about to get even more intense.
portion of the phone calls the court is to understand is basically this defendant speaking with, is it directly with the victim in this case?
No.
No,
An
Your Honor.
attorney.
It's with Mr. Arabo, who's attorney for the victim.
All right. And basically offering to not provide testimony in another case if his client doesn't provide testimony in this criminal proceeding.
That is how I would characterize it, Your Honor. If Mr. Arabo has additional information or different information, he's welcome to.
Yes. Mr.
Yeah, just to clarify the record, that's a portion of a phone call because I didn't anticipate to record the entire thing. I didn't know who was calling me. And then once I realized what this was, which is an attempt to extort and use this other case that he filed against the victim in this matter to use as leverage to have this conversation at a future point in time, I was quick enough to get on my computer and record it. So that the court is aware of what's going on in the matter where I represent Mr. Kwasny, who's the victim in this matter, which is the first matter before the court.
Your Honor, if I may, I really object to that characterization that it was an attempt to extort. I've spoken to Mr. Lee at length about the purpose of the phone call. I also listened to the portion of the phone call.
With everyone back in position, the hearing resumes. The court confirms who has heard the audio clip, noting it's just a small portion of the full call. Even that short snippet appears damaging enough to concern every attorney present. They outline what was captured, a conversation involving testimony, leverage, and an agreement that should never have been discussed outside proper legal channels.
Perhaps the court could listen to it. I do not believe that was what was happening at all. And plus, I don't think there was nothing on there that indicated he was trying to extort this attorney or the complaining witness. Frankly, what Mr. Lee has alleged to me is that he and Mr. Burgess have basically had a breakdown of communication, that he's spoken to Mr. Burgess multiple times, asking him to advocate on his behalf to the prosecutor as well as to this other attorney to try to come up with what he has called, not being a lawyer, using the words a settlement agreement or a plea negotiation. That's what he said to me. And that he had the feeling that Mr. Burgess had not, in fact, made this phone call. So he then called this attorney, and right in the phone call,
because it would have been unethical for Mr. Burgess to call to try to say my client won't testify in this other matter.
Of course.
If that, right? That's
Well,
what Mr. Burgess may not have done.
And